Assalamualaikum Doctor. My name is Ahmad Mus'ab bin Amri, and together with my friend Phakdee and lelaki Seet, we will present the MIDSEM review for the semester. So first of all, I will start with the job scope of a civil litigator. So in civil litigation, plaintiff and defendants in civil disputes are represented by litigation attorneys, sometimes known as litigators or trial lawyers. A lawyer who specializes in civil or criminal cases and represents one of the parties in a legal action before a court of law is known as a litigator. So litigators also attend at additional hearings such as arbitration process or other judicial hearings in addition to representing the clients in court. They oversee the whole litigation process from inquiry, pleadings, discovery to pre-trial, trial, settlement, and appeal. Next, regarding the judgment and order, we'll start with the definition first. Judgment is a situation where a court decision leads to the finality of an action. For example, we can see in court when a direct judgment or default judgment is issued, which marks the end of the case proceedings in the court. While an order is a situation where a court decision is only interlocutory in nature, as we can see when the court issues an order to extend the validity of a writ or an order to amend a pleading. The main difference we can discern between a judgment and an order is that the judgment issued marks the end of the case, while the order is only interlocutory and does not show a final case decision, where the case proceedings are still running as usual in court. We can refer to the case of Boson and Al-Trinchman Urban District Council in the year of 1903, where it was stated that if the judgment or orders as made finally disposes the rights of the parties, it is a final order. Otherwise, it is an interlocutory order. This is called Boson test, which was applied to the case of Harun Muhammad Zahid and Central Securities Holdings in Iran Bahad, which takes place in 1982, and it also approved by the Privy Council. Next, for the appeal process in Malaysia, an appeal for one case can only be made twice. After the second appeal, the decision of the court will be an ultimatum. So there are only three ways the course of an appeal process can take place. Situation number one, if the case starts at magistrate court, the first stage of appeal would be in high court and the last stage of appeal would be in the appellate court. For situation number two, if the case starts at session court, it will be the same as when the case starts at magistrate court, where the first stage of appeal will be in the high court and followed by the appellate court. For situation number three, when the case starts in high court, the first stage of appeal will be in the appellate court, while the last stage will be in federal court. So what is an appeal? According to Oxford Dictionary, an appeal is a process of transferring a case from an inferior court to a superior court in the hope of reversing the decision made by a lower court. So the question is, can all court decisions be challenged? According to Section 3 of Courts of Judicature Act 1964, only decisions by court can be reviewed or challenged, whereas ruling cannot be reviewed. So decisions are made up of three things, which are judgment by court, sentence and order, while ruling is a procedural rule or an instruction that does not determine the outcome of a case. So there are a few types of appeal. Number one, appeal to high court, and number two, appeal to court of appeal. For appeal to the high court, there are three types of appeal, which are number one, appeal from lower courts to high court according to Order 55. Number two, appeal from registrar of the high court judge to a judge in chambers according to Order 56. And number three is appeals to the high court under written law according to Order 55A. So that's all for the summary of the appeal process in Malaysia. Thank you, Doctor.
Hi, I am Phakdee and I Seet A167725. So I'll be explaining for the concept of cost. So first and foremost, we need to understand that civil litigation is consuming and expensive. The term cost refers to the legal expenses that litigation entails. This means that parties have no choice but to bear with the legal expenses in resolving litigations matter. So, the concept of cost is not only for the party to pay for their own litigious expenses, but one also need to pay for the other side's expenses. For example, party may end up being liable and not just for its own legal expenses, but the other party legal expenses too. In other words, the court may be order one party to pay the other party's legal expenses too. By the way, in the event that party that being ordered to pay find that amount of claim by the other party are unreasonable, hence the party can dispute the amount claimed by the other side when making submission to the court. So the court will make a determination as to what costs are reasonable for the party to be bound by the assessment. So next, we should also know how to differentiate the difference between legal fees and legal costs. So legal fees are what a client needs to pay to his or her lawyer for the legal service that being provided by the lawyer to the client. While legal costs is what a judge awards to a party after a matter is decided by the judge. In Order 59 Rule 7 specifies the cost of disbursement, which includes transportations, filing costs, and photocopies. As can be seen, consideration must be given to the location of the transaction, the total amount spent, and the time as indicated in Rule 16. When it comes to costs, the judge may ask parties to submit substantive or even separate cost submission. There are many different types of costs, such as costs here and below, which include all costs from the original court to the higher court if an appeal is filed. Aside from that, costs paid instantly signify that the judge awarded a party cost, which must be paid immediately. So now I will be explaining for discovery and inspection of document. So discovery and inspection of documents refers to the process of gathering relevant document from the opposite party before the trials. This process may be adopted by any of the parties when preparing and completing their case. It becomes effective after the court grant the order of discovery. The parties using discovery method have to satisfy certain requirement for the discovery, particularly on relevancy of the document or information. There shall be no fishing expedition or attempt to discover unrelated documents. Discovery is a procedure directed towards obtaining a proper examination and determination of this issue, not toward assisting a party upon a fishing expedition. Only a document which related in some way to a matter in issue is discoverable, but it is sufficient if it will or would lead to train of inquiry which would either advance a party's own case or damage that of his adversary. Emphasizes that discovery or disclosure should be conducted on relevant documents only and with the intention to determine certain issue. There should be no fishing expedition or discovery of unrelated document. So the need to fulfill principle of for discovery also mentioned in the case of Yekanbaran Marimutu and Malayavata Steel Berhad 1994. The purpose of discovery is to provide the party with all relevant document evidence in each party possession and to avoid trial by ambush or element of surprise. However, the process could also be used as mechanism to delay, harass, as well as driving the other party into financial exorcism or early settlement. So in Malaysia, the High Court has the power to order for discovery. The provision is clearly mentioned by Section 25, Subsection 2 and Para 14 of the Court Judicature Act, 1964. Para 14 expressly requires that these powers are to be exercised in accordance with any written law or rules of court relating to the same issue. So, according to Order 24, Rule 3 of the Rule Court 2012, discovery of document is only allowed upon application by any party to the case and after the court making discovery order. It is also used to appraise the strength or weakness of a party's case, as discovery is the exchange of legal information or known fact of the case. It is the process of obtaining and disclosing the evidence in the possession from each side of the case, so that all parties involved can decide what their best options are. It enables them to consider strength and weakness of the case to decide whether to move forward to the case or seek for early settlement. That's all from us. Thank you.